Okay, go ahead and state your appearances.
Looking for Blanche. Good morning, Your Honor. Teddy Park on behalf of the plaintiff.
Good morning, Your Honor. Eric Pepperman for plaintiffs.
Good morning, Your Honor. Tyler Watson and Jake Suty on behalf of Real Water.
Good morning.
Good morning, Your Honor. Karen Basher and Colt Dodrill on behalf of Nevada Beverage.
Good
Good
morning.
morning, Your Honor. Jim Kavanaugh, Dan Polsenberg for ETT1 LLC, DBA Terrible Herbst.
Morning, Your Honor.
Good morning. All right. So yeah, this is not going to be quick. We've got a few things. Jury questions. So I'll just list off what I think we have, and then follow up on jury questionnaires. At the end or toward the end of the last hearing, I thought it was Mr. Johnson, but it may have been somebody else, said, oh, we've got all this trial stuff to talk about. So we've got that, you're going to be in front of me December 3rd, on the summary judgment to counter summary judgment stuff. But in terms of trial, or pre-trial even, motions in limine, trial weeks, days, whatever else there may be. And then finally, I haven't definitively ruled, obviously, on stay. That issue might take a little more than you all anticipated. I've given that a lot of thought, so that's why I want to save that for last. But jury questionnaires, let's start with that. Is there any progress? That's last.
Yes, Your Honor.
Okay.
So, just to recap where we are.
Thank you. Yeah.
We filed a motion for a jury questionnaire. There was an opposition. Several of the opposition, they opposed and objected to dozens of the questions in the proposed questionnaire. Many of them were changes to the wording. Many of them were concerns about including the questions in there as too long. We filed a reply. We went through all the objected to questions. We went and agreed to modifications as to a couple dozen of them. But we would not agree to strike the questions as being just too long. And when we came to the court came into court last week for the hearing, Your Honor indicated that the length of the questionnaire wasn't a concern and asked us to meet and confer over the questions that were still in dispute to narrow it down so that you could address each question. So we did have the meet and confer on Friday afternoon. On Thursday night, defendants sent us a red line draft of the questionnaire where they accepted all the modifications that we had previously agreed to. They had waived some of the issues and maintained objections to some of the ones that were in dispute. They also had several other changes and additions that were not previously briefed. When we met and conferred on Friday, that was the first time I had the chance to really start going through the red line draft. I said I objected to the changes beyond what was already briefed. It's plaintiff's position that we had a questionnaire, we had ones that were an issue. We were asked to look at those and see what we could agree to and narrow it down. That was the assignment. We had relied on their prior positions on the questionnaire and making numerous concessions in an attempt to compromise. So it was my position in the meet and confer that those weren't properly part of these proceedings and that we should just move forward with the questions that were actually objected to and see what we can narrow those down to. We did make significant progress as to those. There's about 10 left in dispute that I have a list of that we can go through. Yeah, 10. And its plaintiff's position is once we get rulings on those 10, then, you know, the questionnaire is what was previously agreed to, subject to these differences, and that we should go forward.
What 10 do you think are properly in dispute?
So the 10 in dispute, and I'm not sure, Your Honor, if you want to go one by one or just get the list and we can.
Well, so yeah, I was asking essentially for the list from you, I guess, like what is it, number 6, number 12, that kind of thing.
Yes, Your Honor, it's question 23,
23,
24,
4,
47,
47,
48,
48,
49,
49,
50,
50,
52,
52,
54, 56, 57.
Okay. So before we get into the details on those, let's hear from the other side, essentially their take on where we're at with the question.
Morning, Your Honor. Jake Suty on behalf of the Real Water defendants. I candidly, I think plaintiff's counsel did a great job surmising a supermajority of the facts here. I do believe we were able to meet and confer in good faith. We were able to make significant progress on a lot of the questions that were previously objected to, and the numbers that he outlined from what was in our opposition are correct on what still remains in dispute for you to make decisions on. I defer to Nevada Beverage on talking about some of the other additions that defendants are jointly proposing to the jury questionnaire. All defendants agree that we do think it's in the best interest to add these to the jury questionnaire in light of what you told us from the bench regarding length not necessarily being as much of a concern. And so we wanted to make sure we could have some questions that are able to help deal with some additional biases that might be happening amongst the jurors.
Sorry, I might have a question for you because I was trying to follow and
Oh, sure.
Okay, so you agree that those 10 need a ruling, right?
Yes, sir.
Okay, and then most of the rest you're okay with, I think, but you also said something there toward the end of seemed to be, well, if the court doesn't have a concern with the length, then we would like to add some to what's been proposed. Is that what you said? Or I candidly, I didn't quite follow you on that.
Sure, Your Honor. So yes, when we sent a draft on Thursday night to the plaintiff's counsel of the items that are in dispute, there were a couple other jury specific questions to be included in the questionnaire that were being proposed by the defendants jointly. In order to save time and avoid any type of dispute, we presented a defendants joint jury questionnaire over to the plaintiffs that way to help simplify the process.
Okay, thank you.
Yes.
Good morning, Your Honor. To provide some clarification regarding the process, and I agree that I believe Mr. Pepperman provided a general overview of where we are. We did submit a status report for the court this morning. We were hoping to get it on file earlier, but it was filed at 9:24 a.m. in case the court would like to review.
No, I was in here. If anybody
Yes.
did.
Yes, but for purposes of the record and to clarify when we address some of these in more detail later on, Your Honor, I would like to indicate, as shown in the status report, that Exhibit A is the email and proposed questionnaire with our red lines as to what the defense sent over to plaintiff's counsel in preparation for the meeting confer Friday afternoon. Exhibit B to that status report is the email and questionnaire circulated by plaintiff's counsel yesterday afternoon, subsequent to our meeting confer, regarding the compromises that were reached, indicating which questions are still in dispute, and then taking the position that the additional modifications and edits that we had requested, according to them, should not be considered. And then Exhibit C, for clarification, is essentially highlights on the proposed questionnaire from Exhibit A that we believe should still be included in the questionnaire to be distributed to potential jurors. And Exhibit D is just a clean word format listing those questions, if that makes it easier. I understand that sometimes it's a little confusing to review those red lines, Your Honor.
So which of the exhibits would contain the, and I'm struggling how to phrase it, but the new or the newly proposed additional, I don't know how you want to put it, questions that defense want to add essentially? Which one would that be?
It would be C and D, Your Honor. D is just a listing of those questions, just a clean list. And C shows where in the questionnaire we had proposed they be inserted structurally so that they would make sense and be organized for the jurors. I didn't know which would be easier to follow along with. So we proposed it in those formats. But generally, Your Honor, the reasoning, and we discussed this with counsel on Friday, as to the proposed additional edits is it addresses multiple goals, and it is also addressing the status report, Your Honor. It addresses the issue with respect to what has been raised by plaintiffs' counsel as well as the court about trying to gather as much information as possible to try and streamline voir dire. So to that end, we made some additional edits to gather that additional information and to also probe where we might have potential challenges for cause that we might want to address even before questioning additional jurors in the interest of time. Number two, questions with respect to neutralizing some of these questions. In Nevada Beverage's limited opposition to the jury questionnaire, Your Honor may recall, we did not oppose the questionnaire. We highlighted some of the serious concerns that we did have, but we did state overarching that there was concerns about bias in the questionnaire as phrased, that it was unduly prejudicial, and it was we who had suggested that we need to confer, and thankfully, Your Honor, you agreed, and we tried to do that. So the second part about our additional edits to keep in mind is that we tried to neutralize some of the questions where we thought there was some bias in the current phrasing of those questions. Three, we tried to mitigate some assumptions. We believe that the current questions as phrased in this kind of goes towards bias, but presupposes consumption, contamination, causation. And so we want to address those issues. And then fourth, we want to mitigate concerns stemming from the court's ruling denying our motion to continue trial and denying our motion to deconsolidate or sever the plaintiffs. So in light of those concerns about the prejudice that would arise from bolstering and the trial moving forward as it currently states, Your Honor, a lot of the questions were geared towards addressing those issues and trying to determine if that would be a problem. Again, trying to flag potential jurors, potential challenges for cause at the outset, again, in the interest of time. And I appreciate the fact that Your Honor has not made a ruling on the motion for stay, because I think this issue alone highlights the fact that we need additional time to be able to represent our defendants, our clients diligently, Your Honor. When we had a meeting confer, there was some questions or issues or comments raised about these edits not being necessarily quote unquote timely. And our response, true to our words, was that in anticipation of that meeting confer was the only night in the past couple of weeks where we didn't have a bunch of depositions moving forward. So we actually had a few hours to actually pause, reflect, and discuss these issues and be able to address them more meaningfully in order to avoid, potential issues with moving forward with the trial on this expedited schedule with these consolidated plaintiffs.
So we're going to talk about that type of stuff at the end today.
Yeah.
Okay.
So again, Your Honor, this is where we're coming from with respect to those edits. And so I just wanted to provide that as an umbrella for reviewing them. Thank you.
Thank you. Do you want to say anything before I rule?
Your Honor, we just want to address a couple of things, Your Honor. And we've been in front of you several times, not just in this case, but in prior cases and unrelated cases. Your Honor, you're typically fairly firm with deadlines and dates. And I will tell you, to have new questions, and from my discussion.
So I'm going to cut you off because I'm going to rule in your favor. How about that?
Okay, I'm gonna sit down. Thank you, Your Honor.
So, we're going to talk about the 10 in dispute. The court's was not, and this is what I was gonna say before Mr. Parker stood up anyway, but the court's invitation was not a, hey, let's add. Oh, there's, defendants took a position before I ruled largely initially in plaintiff's favor that it's too long. Well, it'd be, it would, let me see, would not be proper, I guess, at this stage to say, okay, well, we heeded the court that it's not too long, so we want to add some now in the process. That ship has sailed. So we'll stick with the 10 that are in dispute. Now I need to find, so if I look at plaintiff's original proposed, or should I look at a more recent version that has those 10 in dispute?
So, Your Honor, if you want to go off our original proposed one, that's what those numbers relate to.
But did they get modified subsequent to that in the being converted, do you know?
Most of them are, they object to the question, or if it is just a modification, we could point out the dispute.
And Your Honor, for reference, on the status report from this morning, Exhibit B contains plaintiff's counsel's questionnaire with the modifications from the meeting confer, and I believe it was in red, the questions that still remain in dispute.
Okay. Well, I may have said this before in your case. I know I've said it several times in other cases. With this type of stuff, I need paper. And I have, well, I've got, yeah, thank you. This is, exhibit 1 to plaintiff's motion.
Correct, Your Honor.
Okay, so let's turn to 23 then. You or your immediate family members have any financial interest in any insurance company? Is that the question?
And I think 24 is the same.
And or field, or okay.
Financial interest and work for insurance.
Well, let's hear from defendant first. They seem fair and innocuous to me.
Sure, Your Honor, and the most on-point case for this matter is Du Bois v. Grant, where inquiry into a juror's potential connection to a casualty insurance company is not even mandated in personal injury actions. However, in its discretion, the court may properly permit such questioning. The key issue, though, it's as talked about on in Silver State Disposal versus Shelley, is the fact that the inquiries must be limited to ferreting out bias and prejudice, and not for the purpose of informing prospective jurors that there actually is insurance on the case. And its defendant's position is that these questions, especially there being multiple of them with very little actual change to them, is designed to put them on actual notice of insurance, and that risks the possibility of there not being fairness to both of the parties, and the substantial likelihood that jurors are just going to make this about insurance. Specifically too, in Du Bois v. Grant, the issue was connections to casualty insurance companies, while this talks about any insurance company. So it's a little overbroad to that extent as well, which further goes towards the fact that it's mainly putting prospective jurors on notice of the idea of insurance, posturing, if you will, rather than actually talking necessarily about biases.
A brief response from plaintiff.
Your Honor, the case law he just cited, it actually supports these questions. We're entitled to know about bias, about if they own it, have a financial interest, or work for insurance companies. It seems pretty straightforward.
These are standard questionnaire questions. They're not actually, it's not calling out, hey, defendants may have insurance or anything like that. It's not posturing. So 23 and 24 will be given as is. 47 is the next one, is that right?
Yes, Your Honor, this is another 47, 48, and 49.
Okay.
I'm not sure what the objection is to these, Your Honor.
Let's hear from whoever on defense side wants to argue.
Yes, Your Honor, it's just our concern is that these questions aren't able to effectively actually demonstrate any type of bias, because it's asking jurors if they think the damages awarded in trial are generally too large, reasonable, don't know, no opinion. The issue primarily is that the news essentially only covers larger jury verdicts. You don't ever see a story really about defense verdicts ever on the local news or anything. So there's a very limited pool that jurors are actually able to see. So asking them to create an average out of something that is usually, the only information they would have is based on, kind of more exceptions almost, if you will, is very tough, and it's not going to show significant biases. And that's, questions 48 and 49 essentially go to the same logic, where it's asking what percentage they think is frivolous of claims that are being made by plaintiffs or defenses that are being made by defendants, because jurors aren't sitting in here. Like, if you look, the gallery's empty. There's no one actually observing, what's going on today. And so they aren't able to actually ascertain whether if, a claim or defense is really frivolous. It's just asking questions that aren't going to give good answers, and it's just going to confuse the jurors, and it's not going to give either party anything that's really effective or meaningful.
Your Honor, do you need a reply from the plaintiffs?
I don't think so, but hold on just a second here. So right now, are we talking about 47, 48, 49, not 50, 52 yet? Is that right?
Correct, Your Honor.
Okay.
I think they logically cluster.
Yeah, okay, so 47, 48, 49. These, in my opinion, are even more proper, if you will, I guess, to give than, I'm given 23 and 24, but these are even more proper, if you could say it like that. And it's going to plaintiffs and defendants. It's giving options. These are, these questions get, and I look over there because that's where the jury sits, but even in non-questionnaire cases, these are appropriate to ask jurors live and in person. So objection overruled. 47, 48 will be given. Okay. Next, 50. Is that tied with any or?
50 and 52 are the next cluster, and this is the specific amount collected. You have the exact prevent you from returning a verdict in excess of 100 million in compensatory,
If justified by the evidence.
if justified by the evidence, and in excess of $1 billion if justified by the evidence, and punitive damages. Your Honor, this one is squarely within Corey v. C-Strand. It specifically says we're allowed to ask for a specific amount. And I would note that the defendants don't have any objection to the other two questions on this, which include a specific amount of 0. It's the same questions for the
Just the other way, right? Okay. Anything from defense?
Yeah, so Corey v. C-Strand is exactly the right case to.
I agree. We all agree. That's
perfect. All right. So, in Corey v. C-Strand, the Supreme Court held that, it's not per se improper, but the amount that was actually being discussed in Corey was $2 million, not billions and billions and billions of dollars, which is very, very different, billion with a B versus million with an M. And the key part too on this one is making sure that it's not jury indoctrination, and that's the court was very clear on in this case in particular, admonishing that the plaintiffs counsel in that case, they were cutting it close in terms of how they were talking to the jurors. They brought up the word million over and over and over again. They asked each prospective juror that question because it's to indoctrinate them. Essentially, the way it works is you get you get the prospective juror to make a commitment that they're going to be able to do what's asked of them before you actually go forward and ask them. At the previous trial in Bonaire, on day 2 of voir dire, the word billion or billions was said 31 times. The word million or millions was said 20 times. And so this is the way that this will actually pan out is it's going to be the conduct that the Supreme Court is admonishing in Corey v. Strand. And in light of that, Your Honor, that's why we're requesting that these questions be stricken because they're not actually, within the exception to the rule.
Thank you. So, good news is we all agree Corey controls. We all have perhaps different takes on what exactly that means. But it does talk about impermissible indoctrination. These 2 questions on this questionnaire certainly are not that. I would also add, if it were justified by the evidence, of course, giving them. My other note says not a vacuum. We've had how many trials now? How many trials and how many of those have a B with a billion with the B in them? Also, one. Say that again.
3 of 5, Your Honor.
Okay, yeah, so 50 and 52 will be given.
Thank you, Your Honor.
54. Yeah, let's just hear from defendant on 54 again.
So these questions are regarding if the prospective jurors believe that there should be legislative limits regarding certain damages. Again, the argument it's very similar to the prior ones, which I recognize is not necessarily great in my favor today, Your Honor. But it's the jurors aren't legislators. They don't actually go down to go up to Carson City. They don't actually look at the reasons why the legislature makes the decisions that they do regarding the limitations of damages or claims or anything like that. And so Your Honor, it's just, again, there's going to be very little information that's actually ascertained to show bias, and so we're asking the omission of these questions.
As you may be able to tell by what I've done so far, I mean, some of these, well, let me back. The court's going to overrule the objection on 54. I think the question's neutral. It's designed to elicit proper information. I don't see any issue at all with 54. So 54 will be given. 56, 57. Let's hear from defendants on 56 and 57.
Sure, Your Honor. And in regards to 56 and 57, defendants aren't asking for them to be stricken in their entirety. It's just small changes to be made. In regards to question 56, it's the word strong is what defendants take issue with. Do you have strong feelings, either positive or negative, about bottled water manufacturers? The only thing that we're requesting is that the word strong be removed and just say, do you have any feelings about positive or negative about bottled water?
Wouldn't strong be a good adjective though? Or I think it's an adjective there. Because couldn't you say basically anybody in the world has quote unquote feelings about that stuff, but wouldn't the adjective be more helpful? Or if not, how is it not helpful?
Sure, Your Honor. And I think that, it's tough for prospective jurors to gauge what strong necessarily means or not mean versus seeing the word strong, telling themselves, oh, I don't think I have strong ones, check no, and then move on to the next question because they're trying to get out of here as soon as they can. So I think if it's just any feelings, we're going to actually be able to ascertain better responses out of the prospective juror. Because I know the meet and confer, one of the issues that was talked about was, some of the prospective jurors in previous trials, mentioned that, they believe that bottled water is, water is life and these people are creating life, you know, if you took out the word strong and asked what's your opinion, they're still going to write that opinion down. But now we're going to be able to capture even more opinions and be able to ferret out bias much more effectively than if it's only strong opinions and the average person is just going to check the box no and move on.
Thank you. Let's hear from plaintiff on the word strong.
Your Honor, I think your comments were correct. It does. It's a question meant to elicit strong feelings. If you ask about any feelings whatsoever, everyone has feelings, so you run the risk of them skipping over it. Strong indicates, do you have something that's worthy of writing down? And that's the intent of the question. And frankly, Your Honor, this question we've gotten responses back that is mostly elicited or favored the defendants, because most people who have strong feelings are that they feel very strongly that water should be safe and it's important for life. And so I really don't understand the objection to this. It's a worthy additive and we think it should be left as written.
Thank you. Yeah, I think the word strong is fine. It's neutral. It's designed to elicit more relevant response than leaving it out. So 56 will be given with the word strong. 57. I mean, this would seem most relevant of all of these questions, but what's defendant's objection on 57?
Same as 56, Your Honor. We're not asking for omission of the question in its entirety. It's just a modification for question the second part where it's a sliding scale of 1 to 6 about any concerns that they
Oh,
may.
on that, sorry. Okay. I didn't see the second part. Sorry, go ahead.
I'll give you a minute to read through it if you
No, go ahead.
It's the 1 through 6 sliding scale about concern over the safety of the alkaline water that they're drinking. Again, this is a it's an indoctrination issue, Your Honor. It's presupposing the idea that there's something wrong with the bottled water, and that's the concern that the real water defendants have, is that it's not going to actually help ferret out bias. It's just going to indoctrinate the jury regarding issues for when it comes time for trial.
Give me 1 second or a few from plaintiffs. Let me. Any response from plaintiffs on that second part?
Your Honor, I don't understand how this indoctrinates anyone. If they have a significant worry, then it's something that is potentially worthwhile to follow up on for both sides. This one, it's been in all the other ones. I can't recall anything specifically concerning or either way, but we'd ask that it just be given as written.
Yeah. Yeah, like I said, even with, now that I've reviewed the second part of 57, it's seen again, solicitation of highly relevant information. I mean, this is a type of question that could be asked in jurors' presence anyway. I'll give 57 as well. Anything else about the questionnaire?
Your Honor, one last thing. In terms of the date to get the printed copies to the jury services, I'm not sure if the court's prepared to address that today.
That's a good, do we know? Yeah, I was like, that's a good question. As I sit here, I don't know. Contact either Ms. Rivera or the commissioner. Yeah, I wish I had an answer for you, but
No problem, Your Honor. We'll contact jury services.
and that's part of why, like, yeah, let's get it done because of the timing. Okay. Okay. Pre-trial motions, trial days, weeks. Was I correct in saying Mr. Johnson raised that at the end of this time?
I believe so.
Who's here on his behalf, I guess, maybe?
I am, Your Honor.
Okay.
And the primary question is just if we know, whether we're going to be set firm or not. I know the parties had agreed tentatively for January 20th. There was an indication the court was open to it, but it's not been memorialized, and we're trying to juggle some other trials that are also on that January 5th stack in different departments.
Did plaintiffs have an understanding about January 20th?
Judge, I think you came up with that day. Way back. Kind of run with that.
Bear with me a second here. Let me log in.
I think the legal concern was you said you had some med mal cases that were taken the first 2 weeks to stack, and so that's where anyone pointed out.
Okay, let me log in because that type of thing's always fluid and gets better firmed up as you get closer. Yeah, so the pre-trial and calendar calls. Let's take a relatively quick break because I gotta go get our trial sheet that I don't think I have right here. And check up on that. But yeah, let's take like 10-minute break. Right.
Yes.
Okay.
No.
We did that one trial before. Do what you did before. Contact Miss Rivera on the questionnaire. January 20th, totally fine. You're in first place. The stack ends on February 6th.
That's correct.
That would give you 3 weeks. Right?
Yes, sir.
And as you all know, unfortunately, my days are not full. So 3 weeks. I mean, we tried the other one 3 weeks,
We
right?
did, Your Honor.
Yeah. Any question about trial days, weeks? Everybody okay with that?
Yes, Your Honor.
Oh,
Thank you, Your Honor.
yeah, no, thank you all. Anything else about trial or pretrial motions? Any questions on any of that?
Your Honor, I think we do need to decide on a hearing date for the various motions in limine.
So have any been filed yet or?
Tomorrow, Your Honor.
Okay,
Lemonades are filed tomorrow, so we're anticipating probably about 80 from both sides, I think, is that?
like 80 each or 80 total?
80 total.
Okay.
Out of those, I think 65 or so have already been ruled on by the court, which we're going to indicate in the motion. So there's probably 15 new ones. And then the summary judgments, there's 6 of those.
Yeah, those ones are pending right on the 3rd.
So some of them are, I'm anticipating the defendants will file some more.
Oh, okay.
Remember, we filed ours 3 weeks early to get it.
And some people weren't happy about that timing, but you've got a hearing date on the 3rd on what's been filed. So in limine, what all are you suggesting, if anything?
Probably need at least a full day or.
I think we did more than 1 day, right?
Yeah.
Just not full days.
Remember that 65 already have rulings. I know they're going to want to re-argue something. At least we're starting from someplace.
And Your Honor, in the previous trial, we got together and decided which ones we could just submit without argument. We'd be happy to do it again.
Okay. And by we, you mean we defendants collectively in plaintiff, or
Yeah,
some
last trial was
defendants?
actually- The last trial was just Real Water as the defendant, and we met with plaintiffs' counsel and came to an agreement on some that could just be submitted. And speaking for Real Water, we'd be open to that again.
Anything
This
from,
would be pretty well joined at the hip, Your Honor. So I think-
well, I mean, I'm not sure, so that's why I'm asking if, anybody else on the defense side disagree with that, or?
No, Your Honor, based upon the review of the briefs, if we can come to an agreement, we'll definitely entertain that. We will oppose some of these motions. Obviously, we have not been to trial before, so that's going to be an issue, but to the extent we can come to an agreement prior to the hearing, then we will advise and enter in any stipulations.
We'll probably need to coordinate more. And I'm thinking out loud, so I apologize, but we'll probably need to coordinate more. Not sure we can right now. On the 17th of December, you know, the pretrial conference calendar call for everybody. And I don't know that I can, you know, like reserve an afternoon or two right now. You know, given that there may be trials set. I also understand you're gonna need more time than normal hearings. We might need to give you hearing dates on the 17th of December. Or maybe.
Sorry, that's not what we want to do that, but we do have to know trial.
Oh, yeah. How many, sorry, going back, how many jurors do we need to order?
No, we're trying to figure that out. Mr. Pepperman believes 600, but I think the last time we actually did less in front of Judge Williams.
Okay,
Yeah, I'm
Good.
struggling to recall the number. I thought it was 400. Is that right?
I was getting ready to say 3, so
Okay.
it's all over the place, Your Honor,
Yeah.
at this point.
so
I know
Mr.
it's less. The questionnaire helps quite a bit, Your Honor.
Yeah,
And we actually didn't have to go through another set at the end. So we were able to make use of the first pool we had.
and I know in the one we did, Mr. Rivera reminded, we did 600 in the one I did, and it was, you know, caution's good, but it was 600 was way too many.
That's right.
So think about that, I guess, for next time we talk.
Yes, Your Honor.
Okay. Any other trial related issues? Before we talk, and I unfortunately was reminded I have a meeting at 12:15 that I can't miss. So we might have to bring you back after you hear some thoughts of mine, but anything else on trial issues?
Your
Okay.
Honor, good afternoon. Colt Dodrill, counsel for Nevada Beverage. On the pretrial motions to be filed tomorrow, do you want us to put hearing date already set on 12/17, or would you prefer we leave hearing requested on there and you issue a clerk's notice of hearing?
Yeah, you do hearing requests, and the clerk will give you a date on that. 17th is my pretrial conference, right?
Right.
And calendar calls, so why I talked about the 17th, we may need 17th would be where hopefully I know better my schedule before January 20th. And that might be the date where we can coordinate a hearing on the motions in limine, essentially.
Thank you, Your Honor. Just making sure you didn't need special language in the caption.
Yeah, no, thank you. She wasn't here before. Joint exhibits, electronic paper.
Electronic exhibits. We've typically tried to narrow it down so that there is a plaintiff set and a defendant set, and there's minimal duplication, if any, but it'll probably be separate sets.
But electronic, right?
Electronic, yes.
Any other question on that?
We'll just send out the guidelines to everyone so that you can reach out to the evidence vault. We might have to establish what number each party gets. So if you guys can just have a number for us when you respond, and that way we can assign something before you reach out to the vault.
Yes, that's what we've done in the past, and we can do that here, no problem.
Thank you. Okay. Stay deconsolidation. Have a lot of thoughts. Do you want to hear some thoughts and then we come back next week, or do you want to do everything next week?
Why don't we do everything next week, Your Honor? Because you're gonna be cramped for time.
What day next week?
When is Wednesday you're coming from me?
Yeah, we're at the December 3rd, Your Honor.
That's gonna be like 2 weeks.
Well, okay, I'll give you my thoughts then. How about that? And we'll, well, I could bring you back on Monday too, if you want. Monday, this.
Or whatever's easier.
Well, I'm gonna give you some, I'm gonna go ahead and give you thoughts right now. It's probably better to have plaintiff hear this so that they can maybe respond. And so I gave this a lot of thought, and it made my job difficult. Defendant's motion to deconsolidate, the primary argument was, well, we didn't know about this cancer issue. And that was clearly not quite accurate, is how I generously put it. Secondary argument was, well, we don't have the resources. That's also not a very strong argument. So it made my job difficult. Plus my schedule, as you've obviously all seen, is pretty packed. But when you make arguments that aren't super helpful, you may get rulings that go against you. Even on the reconsideration, there was little focus on what to me are the real key issues. So going back, in the consolidation way back in May, my reasons for consolidation were, there's not a lot of surprises. We've had substantial production of documents. Certainly wasn't complete. I agree with defendants on that, but there were thousands of pages produced ahead of that. Plaintiff argued persuasively slow that they'd rather do 6 trials than 7 trials. Maybe we need 5 depositions. Defendants raised, we need purchase information. 6 months ago. I said, defendant's argument about lack of time could be addressed with continuance. Plaintiff understandably noted, hey, we don't have a real issue with moving trial to January if that's what's needed. And so we did that. Then 2 new cases are filed. And this, I think these are defendant's strongest argument and it makes it hard. But let's see, so Herbst, which is the one we're dealing with here, it's a wrongful death. It has retail bottles. It has Terrible Herbst. It has Nevada Beverage, filed February 2025. Post consolidation and pre filing the motion to deconsolidate. We have two new complaints. So we've got Sotero's September 9 wrongful death case involving retail bottles, involving Terrible Herbst, Costco, Nevada Beverage, September 9, 2025. We've got Jaster filed September 16, 2025. And Sotero's, I think I said wrongful death, but if I skip that, that's a wrongful death case. Jaster, wrongful death case, retail bottles, Sprouts, September 16, 2025. So it seems to me, and candidly, I don't know why defense didn't lead with this, but we've got a total, at least as I sit here and I'm aware of, there are 3 wrongful death cases filed the year 2025. All 3 apparently involve retail bottles. All 3, at least as of now, have a retailer / distributor as a defendant. So let's talk about on December 3rd, if you want to wait that long, or I'm also free December 1st about, should I actually deconsolidate?
Let's do it December 1st, because I think the big thing you're missing is taking Jaster, for example. That's an ALS case. The causation is all going to be testimony from neurologists. There's not going to be hepatologists in that case. So to suggest that we can consolidate Herbst into Jaster, I mean, that's the same decision you made in Quebec. Not only is it a completely different mechanism of action, at least Quebec was acute liver failure with a transplant.
So I would welcome definitely a response from plaintiffs, and that's part of why I'm like, well, here's my thought.
Your Honor, you should file a quick position paper to come back into the first.
Well, if they're filing a quick paper, let's come back on the 3rd so I can read it before we get into court.
Well, weren't you the one that complained about the 3rd
I
too?
was.
Too far out.
Foolish consistency is the hobgoblin of little knots.
What day do you want?
3rd would be good if we can. I have
Well, you're
a status check in front of Judge Williams on one of the COVID coverage cases. So if we can, if I can talk.
I'm gonna call you last on the 3rd. Even if somebody wanted to be first, I'm gonna call you last on the
We
3rd.
just have an 11 o'clock setting or something.
Well, we've got let's say you don't need to even be here until at the earliest 10 a.m.
Sounds good.
Do we have a trial?
No,
Thank you.
but you have other stuff going on, but no,
Okay.
you don't.
That's
Yeah, we-
okay. So I will see you all back on the 3rd on our 9 o'clock, but you don't need to show up until the earliest 10.
Thank you. Thank you.